Furthermore, your lordships, in the case of Sri Lanka Vidyarthi versus State of Uttar Pradesh Hostel, page number 7 and 8 of the complaint. It held that any state action, by page number 7 and 8 of due to logistical issues, only one copy has been made available. In this case, the word state action has been used. While we consider that the prosecution is also being done by the state, and the police are also functionaries of the state, any action that they take must follow the essence of rule of law. That is, that every people reason to their decisions or to their and leaving aside their personal predilections. That is what all the facts of that particular case. Yes, sir. That was originally stems from civil jurisdiction and contractual law as well. That he law laid down that any state action, including contractual factors of the state, must follow the rest of one civil cases. These are only for criminal cases. For civil cases, goes on the preponderance and probabilities. But whereas criminal cases, it's beyond reasonable doubt. So, how was that ratio laid on in this particular case as second response is applicable on buttress your submissions in this case? The answer is relying on the principle or the reasoning that was mentioned for Article 15 as well. Because while we discuss about the definition and how the definition led to the powers of the Act is anything arbitrary enforcement. Thus, even though the ratio may not be directly applicable and not binding upon this code, the council is relying upon the reasoning behind this code. Your lordships, also, there are no objective standards. Usually, when the state gives a classification in the provision, it also gives the schedules as to how this classification has to be looked at and how this classification has to be utilized by the authorities on the ground level. But however, another instance is that there is a complete absence of any such schedules or classification. This objective standards, when the legislation does not lay it down, it leaves open the interpretation and the enforcement to the police authorities on the ground. And your lordships have repeatedly and time and again, even when the procedure for arrest also is given very clearly and the clearances, time and again guidelines have been. Even when it comes to the matters of issuing of notices as well, the guidelines have been given. So, as for the date of arrest, is there any privileged type of SOP that was submitted of government? Because under the transition period of CRPC, the DNS is coming into force. So there was no SOP. So that being the case, how can you draw the procedural standards of the banding as listed in the brief? Because under the transition. So was there any SOP in place when the constitution? Your lordships, the SOP in place, the reason for the contention was that very recently, in a case regarding arrest as well, and also under 55 clause 3 of BMS also, judgment given by the Karnataka High Court was also affirmed by the Honorable Supreme Court. No, it was an extension of the we have the judgment brought to this. At least we know the citation or the party. At this moment, I'm unable to recall the name, but however, it was a judgment from Justice Nagaprasad, which was affirmed by the Honorable Supreme Court. In this judgment also, it was said that any notice issued by the police has to only be RPA. There were instances that it was being sent through WhatsApp or it was being directly communicated as well. So even when the procedure is laid down very clearly, there has been a necessity for guidance. But here, the procedure itself is not so exhaustive that it leaves open the procedural gaps that can be exploited and is being exploited. And with relation to the contention of cases of force as well, there is a term that is reasonable force that has to be used, that is being provided by the statute and 51 and 52 as well. But however, the same standard here, when this act is telling the person that at that time was Mr. Abdul Fasih, really hesitated to give these biological samples. The question is, does this mere hesitance transforms it to refusal and resistance that the police even has to use force in the first place? It was not really reasonable force, but it was excessive force that was used. Into the visible injuries and then that's on the neck and hips are the conscious. So when this force is being used unilaterally without without an obligation, any of this blanket use of force, that is what is arbitrary and is given to excessive force.
In the case of the state that this person has committed offense which is punishable more than 7 years. And in that time, the state has presumed that he is an offender. Therefore, involve course, that rule is that you should be, something like short. That is not a mistake. That is something only for the bench. I guess I think he was coming here. He is that strictly percentage. That's why while collecting the samples, they know they are forcing to take the samples. In that situation, there is no only God assuming that there are some injuries on the body, hence the police have taken police are forcing and given a torture. That is not presumption. It is no in the rights.
Your Lordships, with regard to the presumption that he is an offender by the state as well. At the same time, the state also has the obligation to not violate fundamental rights of the individual. And under Section 56 of the DNSS also, it states that the health and safety of the individual in custody of the police officer is the responsibility of the state itself. And thus the contention of injuries indicates that while he was in police custody, if to such an extent that visual injuries such as bruises on his face, swelling under his eye, and a cut near his lips, merely for recording of biometrics or merely for drawing a blood sample, if the police are cutting his near his lips and extracting the blood samples, that very clearly amounts to excessive force violence.
Yeah, what is the procedure to claim the brand?
Your Lordships, again, when we now to illustrate to that answer, Your Lordships, if the person is resisting, holding down by his hands and legs would be more than sufficient to extract blood. Or even for biometrics, a person may hold his shoulder and it may be extracted from the finger of that person.
What is excessive resistance is being shown? Exactly, it's only the excessive resistance and I'm should accuse. The biggest accuse.
There will be no excessive resistance by the.
So you see, so that we just need a substantive or outputs in the state.
However, it provides the fact sheet clearly states that the person hesitated in giving his biological samples. The question here is, does here hesitance? Hesitance can mean move that and move back one step. But here, when I move back one step due to my hesitation of giving my biological samples, it can resulted in me like abuse and use of excessive force.
And unless my brother can just have just clarify.
Your Lordships are satisfied with the issue 1 million also proceed with the issue.
Please go ahead.
Yeah, I'll proceed with issue 3. We should do issue 3. Regarding group 193 and issue 4. Your Lordship, issue 3 pertains to whether the non-consensual collection of biological samples, authorized non-consensual collection of biological samples, violates the right to scientific examination under Article 20,000. Your Lordship, Article 20 of 3 reads that no person shall be compelled to be a witness against.
What is when you Article 22 is mentioned in the Constitution, what was the legislative
intent. Your Lordship, the intention of at that time when this article was implemented in the Constitution was that no person should be forced to give any testimony against himself and also to not be forced to take a bill for any other crime or law. That is, no person should be made a witness against himself in his own case under duress or compulsion. That is why there are 3 core elements of this article, as laid down by the first and foremost case that interpreted this article, that was M.B. Sharma versus Satish Chandra. Where the first one was that the person must be under formal accusation. Secondly, there must be authorship or duress. And thirdly, this compulsion and duress must result in the person being a witness or giving evidence against himself. Here, the condition is regarding that the manner in which the biological samples are being collected, that should be held as testimonial compulsion. Your Lordship, testimonial compulsion, and even as very raised by your Lordships regarding the Indian and 20 plus 3 was that, where any testimony is obtained by any arrested person in the custody of the police officer or even in the court, that testimony will be inadmissible before the court due to the nature of the compulsion and the duress. This is also giving the right to right against self-incrimination. But here, in the manner that this biological sample is being extracted, also that whatever samples that would be useful, the only work that the police is doing here is they are extracting the biological sample and producing it before the court. This is acquiring the testimonial purpose. And even in the case of KLE Law College versus State of Andhra Pradesh, Indian Law, State number 31 of the law.
was the issue that
Your Lordships, this case was primarily regarding there were certain
just people things to sign. But that
there was there was certain state number 31 here. You the relevant portions. In that, there were certain accusations against forgery of certain documents. Here, police sought DNA and fingerprint both persons. While the court held that fingerprints can be allowed to extract DNA, certain standard must be followed. And the standard is that there has to be substantive investigation already done by the police. The evidence has to be collected. And when the DNA can be acquired is to corroborate the material or the medical evidence already on record to the police. But however, in this instance, due to the nature of this act as to how open-ended it is giving the police the authority to substitute their investigation obligation and collect these biological samples and use it for the purposes of testing. It can be very easily said that instead of beating a testimony out of a person, that is what is prohibited under treaty clause 3, they are beating out these biological samples against the individual. By taking these biological samples, relying only on this for the prosecution, that will also be the judgment of the trial court for this conviction. This is what is acquiring testimonial purpose. Even in Selby versus State of Karnataka elections, page number 32, there were the lordships in Selby draw a difference between DNA sample and DNA profiling. The mere collection of the DNA sample might not be self-incriminatory in nature and did not face constitutional questions at that time. But when this DNA profiling and techniques are further advanced and it is used for a testimonial purpose, that is when the constitutional question under Article 20 clause 3 arises. So as we come to the introduction,
In the present case, how the police have collected these samples and why they were collected? Not how, why they are collected.
it is to with regard to the offense of attempted
How do you call investigation of the truth for whether he has committed the offense or not? You are there.
that is the part of it.
So identification of truth. How do you think that when collecting sample is self-discrimination to the different side?
You have certification. There are two conditions for the collaborations. The first is that while collecting it only for identification purposes, for corroboration purposes, to that extent it may not be self-incriminating. But post that identification when it is illegal, when it is being used for the conviction purposes, solely for the conviction purposes, that is when it is being self-incriminating. The second point is in Nandini Certificate versus Clear Daniel Merchants, page number 26 of the complaint. It held that any kind of physical force and intimidation also amounts to duress and compulsion. If your lordships can kindly please refer to section 6 clause 2 of the criminal procedure.
Protection under the law that as per section. As per section 3 plus 3. And also, that provision is also given in make a clear directions that providing the 80% ownership of an foreign offense committed under the ending of one time each vote, except for an offense committed against one object or any offense of financial ownership of there is not a number of checks. The victim is not checking by the check. This common check that the offense is punishable for containing 7 years. The government exceptions, then where is self-incrimination?
Is self-incrimination what about the rights of the victim? Okay, indeed, but self-incrimination is arising, like this provision is right in section 6 clause 2 as that any such resistance also is being penalized under the 196 of IPC of actions. That is disobeying the local order of a government officer.
Provision not a link
The provision and this criminalization is resulting in criminal intimidation of prosecution. In anti-consumptive versus peer time also what at that time somebody was police to themselves intimidate for prosecution. But now it has been introduced.
also similar provision.
Similar to the both specific provision. At that time there was no such provision. But the principle that recognizes intimidation also in any form that will result in duress will amount to self-incrimination. Any evidence secured by that matter amounts to self-incrimination. Here in this instance, I think 6 clause 2 as well, in the provision, when there is a threat of prosecution directly by the statute itself, and even then the person will be left with no option but to comply with the order of the police officer.
To my so, sir, also, it's a right of the lead from section 3. We got it to know.
Yes, sir.
It provides for certain things, and then the legislation provides for the provision. It is a rider that the provision of section 3 is to direct subject to the provision that has been attached to it. So that is to say, it's an exception to the rule, right? So how you are going to substantiate that the provision having to the substantial provision, it provides excessive power to the police.
Your Lordship, in the substantive provision that when an offence is committed against a side of 7 years, it is mandatory for the judge and non-consensual to provide the biological samples. But again, for self-incrimination here, if for identification purposes, as recognized as physical evidence there, it is not self-incriminating. The counsel does not find it well. But when it is advanced to the testimonial purpose, when it is being replaced to the testimonial purpose, what is happening here is this exception itself is being leveraged by the police officers to mandatorily collect. So they also have the provision in 51 and 52. In fact, in 52 also they have to get the examination done of the arrested person within the 16 kilometer radius. I'll conclude the one expansion. Your Lordships, I'll just summarize since you mentioned that for excessive delegation and excessive use of force and arbitrary enforcement of the section 2(1)(b), biological samples is negatively applicable. It has to know clear safeguards or any such limits have been prescribed by the legislature to what extent that power will be utilized. And for self-examination, Your Lordships, the mandatory biological samples will be collected, and the mandatory clause, the exception provision is being leveraged by the police officers to substitute their own investigation obligations for testimonial purpose is what is amounting to self-incrimination. I go once in brief. Thank you.
The consistency established to address the rights directly to the functions. The functions are constantly given the patient 24 of the present case. In patient 24 of the present case, when patient notes whether the outsourcing of other proceedings by medical samples for private liability without safeguards amounts to excessive delegation under the Act and infringes the right to privacy guarantee under Article 21. The Lordship's Article 21 reads as no person shall be deprived of his life and personal or personal liberty except according to the procedure established by law. In the present case, the Lordship does not have considered written under the Rules 2022. That is given under Rules 3 and Rule 5 of the Rules 2022, the Lordship. Wherein the Rule 3 states that taking of measurements.
Bench wants to know, apart from this particular rules, also the human identification, procedure identification. Is there any extant law providing for rights of personal income or rights of personal income?
In the Lordship, there is DPDK.
When was it? 1 year.
2000.
Okay, no issues.
Lordship. In Rule 3 and 4 and Rule 5 of the Rules 2023 Lordships, the procedure has been given. The procedure as to the taking of measurements and the manner of collection, storage, preservation, sharing, dissemination, destruction, and disposal of materials. Your Lordships, the problem over here is that such procedure has to be judged fair and reasonable. As we under Mahatma Gandhi Lordship, any procedure which has to be established by law, it has to be judged fair and reasonable. In the present case, when there is a procedure given under the rules, then it is not judged fair and reasonable because there is excessive delegation. How to establish how to get excessive delegation and how it is just not just fair and reasonable one by one Lordship. As in Lordship, already the excessive delegation has been done in the, I would like to draw the weights of the attention to go on the section 4 of the Act of Lordship. Section 4 of the Act reads as the NCRB shall, in the interest of prevention, detection, investigation, and prosecution of any offence under any law for the time being in force, collect the record of measurements from state government or unitary administrations or any other law enforcement agency, store, preserve, and destroy the record of measurements at national level, process such record with relevant crime criminal records, and share and disseminate such records in any law enforcement agencies and such manner as may be prescribed. The Lordships of the law, the emphasis is on the words store, preserve, and destroy, and the emphasis in the first clause itself, it is the NCRB shall. In the present case, the Lordship, if the Lordships may refer to fact sheet, paragraph 7 on the page number 2, your Lordships, the last third line, the
A of section 4. The emphasis on clause B, but however, clause B, because that comes together, better of clause B. Carrying recipients such a course of quality was the final aspect of right. So, what an emphasis to clause C. Clause C, I mean clause B, right? Clause B. B. How is this bypass with the enabling function in subclause B?
So, the lordship for the contention of the council is that when the storing and preservation and destruction of the records has been given to the NCRP, such cannot be delegated to a private company. According to the facts of the fact sheet reduction, paragraph 7 on the
It's a constitution to delegate the powers that the legislators have got the power to delegate also, when you get some authority, some authority to do some work. How does only some body to do all the work? You don't have to delegate to whatever.
Your Lordship, delegation is allowed. Your Lordship, but the delegation has to be with safeguards. In the present case, Your Lordship, the issue itself is stating that it is without safeguards. In the present case, there are no procedural safeguards or legal remedies as to the Act, Your Lordship, because if at all there were procedural safeguards, then when the right to privacy was breached of the prisoners and the criminals of the prisoners of the residents, then Your Lordship, there could have been a safeguard as to that the privacy is not breached. Because Your Lordship, when the government is collecting sensitive data of the citizens, then the government has the responsibility. It is the reasonable expectation of the citizens that the government will protect their information if it is collected by the government. Now, when such information is given by the government to a private company, the reasonable expectation of the citizen will still remain.
And also, your pretense only with respect to the handing over of your matter to the private agency. If it happens to be a state agency, probably you would not have been there.
If it had been a state agency also, the extra delegation wouldn't have been there. The issue itself is probably
Even then, you could have challenged.
indeed your lordships. Your lordship, if the right to privacy is breached, then I could have gone for the challenge, your lordship.
Do you think that the state was not quite SOP for correcting these numbers? That amounts that leads to that gives access to delegation.
Indeed, your lordships.
What the legal says. But however, please read clause B, subclause D of section 4. Share and dispute such because any law enforcement agencies in such manner as may be prescribed. It all changes law enforcement agency. Law enforcement agency can either be private or state agency of the state.
Indeed, your lordship.
So how this particular discrimination, just make a distinction of your wasn't affected by that's a begin.
Your lordships. Furthermore to that, law enforcement agency in such manner as may be prescribed. As being prescribed to the rules, your lordship. As in the
Which probably tracks explains the expression. Right?
Sections 1 clause D, your lordship. Yeah. Whether it is written and prescribed, please prescribed by the rules made under the act.
So how is the rules made into this?
Under section 8, your lordship, when the central government and state government.
45. It's not at 45. It's the rules. That's what answer. Express in opinion as well. Earlier, there was a question that is the answer to the
Thank you, your lordship. I would like to answer it now, your lordship.
See, that is a collective question which is being expressed in different ways. Next, so you put address it collectively. The same thing leaders in the minds of all the leaders.
So, in the rules, your lordship, there is nowhere mentioned that the private agency, the delegation can be made to the private agency. Because when in section 4 itself, your lordship, when we are interpreting it as together, then when it is stating that in such manner as may be prescribed, then it has to be prescribed by the rules at least. If the act or the rules is not empowering such NCRP to make such delegation to a private company, then how such delegation can be valid? It has to be an excessive delegation itself. Moreover, your lordship, when such delegation has been made, the right to privacy has been breached. Apart from that, your lordship, there is no accountability or enforcing thing. Because if such delegation is made by the government agency, government body, that is NCRP, to a private agency, the enforceability will not be to the private officials, the employees of the private company. If it was a government company, your lordship, the petitioner would have gone under Article 34 to 26 for the enforceability of the rights of right to privacy. However, in the present case, when such delegation has been made to a private company, then such enforceability does not lie with the petitioners. And moreover, Lordship, considering the status of the citizens of the nation, it cannot be stated that every citizen will be able to go to the Supreme.
You expect that the government agency will take that from the result or result other than private agency. How do you say?
Look, before this court, questioning the constitutionality of this provisions of law on the context at the angle of excessive delegation for not having prescribed. I'm going to say those things, but that is what is that right?
Indeed, Your Lordship, indeed. Your Lordship, in the Act itself, it is nowhere providing for any. It is nowhere providing for the delegation.
Yes.
It is nowhere. Sorry, I will say the Lordship. It is nowhere providing for the delegation which have been made by the NCRB as in the Act, Your Lordship. However, Your Lordship, if it is not providing for the delegation,
Section 4 is a delegation powers is there.
Your Lordship, such powers have been given to the state government agencies or state government administration.
We classify in a proper that is one such thing.
Your Lordship, NCRB is a central body. It doesn't come under state government administration or union territory administration, Your Lordship. When they refer to the word state government and union territory administration, they're specifically talking about the local administration as the state or union territory administration. So, and over here, when the NCRB is doing that, that is not given under any of the clauses or the rules or the act itself, Your Lordship.
And what are the principles that you are laying down for to show that this is more accessible?
Your Lordship,
Generally, principles that you are laying down, or you want us to designate a particular act as an excessive delegation. You must have certain instances as to how, or you must have some examples as to how you the first principle. This is what excessive delegation is.
Your Lordship, the council is relying on the impugned act itself, where it is being.
You want us to rely on the first principle, or is there any past precedents? Yeah, then you are getting up. If you want us to consider this as the first principle, you please don't say the in principle, or you are relying upon the past precedent.
Past principles itself, Your Lordship.
Past precedents, which part of the comprehension is relevant?
In the commenting with Your Lordship, as of now, there is no precedent as to the executive delegation.
If it's already about principle, or you are not aware.
And at this moment, Your Lordship, the council is aware of the president's certificate.
Anxiety of my other abilities to understand as to whether we spoke in another previous cases I wish to add an opportunity to discuss with regard to the answer that you are putting forth.
Indeed, Your Lordship, there was a discussion about the essential legislative function which has been delegated by the government. However, Your Lordship, in the present case, that the council is challenging it's a sub-delegation made by the NCRB to the private company. So, essential legislative function is not the question over here. Hence, the council.
What you have
As to the right to privacy of options, as we can already see in the paragraph of the fact, paragraph 8 of the fact sheet, Your Lordship, that second line, Your Lordships, although initially described as an attempt, subsequent disclosures revealed that there was indeed a breach resulting in the leakage of considerable volumes of sensitive genetic data, including DNA profiles, prisoner photographs, and biometric identifiers. Your Lordship, this fact is stating that there was indeed a breach of privacy of the prisoners, which was collected by the NCRB itself and later on delegated to the private company itself. Hence, Your Lordship, it can be said that if such violation has been done by the NCRB, and there are no safeguards as to the delegation, and when the NCRB is delegating it, then it cannot be considered as act is constitutional, Lordship, because it is speaking ambiguity in itself.
The accused of administration of current discussion about administration. That is not the POXO. POXO, unlike the other provisions that starts with legal on the spot. In criminal proceedings, the onus is to be on the state to prove that he is accused. But unlike POXO Act starts with goes on the spot saying that the accused should, the onus is on the accused to show that he is not guilty. So how would you bypass this particular provision of the government? Because the particular samples have been collected with the distinct proof that it's a reverse on the class to establish So how do you bypass that?
Your Lordship, as to the issue number 2, it is just about the delegation which have been made by the NCRT to the
That is not my question. The dedication is to establish and actually the reverse owner's clause is being embedded in the
Your Lordship, if you could please.
reverse owner's clause also starts with an asking the reverse owner's clause.
Indeed, Your Lordship.
So the excessive delegation, assuming that the benefit of the prima facie opinion reflects. But or you have to assume that there is excessive delegation. Is to incriminate the offense that is being the charge accused. So how do you bypass it?
Your Lordship, the dedication is excessive because the Improved Act is not provided for any kind of dedication which have been made by the NCRT. Moreover, Your Lordship, as to if the dedication was not to be considered as excessive, there would have been accountability measures or there would have been procedural safeguards or even legal remedies. Because Your Lordship, even up to the right to receive.
Then why you are saying that unconstitutional and unconstitutional provisions are constitutional? This is will extend even direction to the state to make some rules for collecting the samples and estimating the samples. Do you reply your question?
Indeed, not Your Lordship, because even if the provisions of the Act are not
Excessive delegation is provided in the Constitution. The legislature to give, delegate the powers of the executive or state body to do some work, not for private entity. That the provision of Section 50, Section 4 of SB was not given the provisions to be only the private agency. Earlier, as pointed one point, question that how to determine that how to determine that the private government agency will give a proper result to take a samples and other things. Because that the private agency will not have any accountability. That's why the state, the duty of the state to make some rules and the state has to answerable for to protect the rights of the citizens as provided under Article 12, 31, 32. We are with it. Whole discussion is only to summarize what happens.
Well, the judge is helping me.
These, but I answer all the questions.
And so also the basic principle remains upon which constitutionality is to be examined is under the principle that all fundamental rights are not absolute as you and every fundamental right has its own restrictions and reasonable restrictions to be imposed. That is what our case is. In the present case, as you have already submitted, is that like by giving excessive over delegation to the state agency or as to some agency, your fundamental right has been breached. And the thing is, as the offense, unleashed regulation of right happens to be a serious offense, which is an extra criminal legislation done by the state. So that is why we have to go with the way that the constitutionality or other things for the practical purposes cannot be strictly adhered to for the simple reason it is in the interest of the citizens, it is in the interest of the state that has to be given importance rather than your fundamental rights.
Right? The explanation was not given about 80 or it is also a duty of the state to protect all citizens. Yeah, we don't stringent punishments. We don't really a proper correction of your rights. How the people will be safe in the nation. How the person is safe. Then the question is there. That is the next one. Those thousands or the state is not made a stupid or handed over the delegated the house for contracting this one service to the teacher. Make some appliance there. The routines being authorities supports.
So, for the right to protect itself, the council clear your options. Because the
They
state
are not there for the rights to often beat them. They are represented the accused, right?
petitioners
I mean, the petitioner, who accused me the father of the accused.
yes, sir.
Yeah. Who is the victim? Who's the victim and who is the victim?
In the present case, the accused is the accused, but however, the victim and then the victim of violation, when the violation was made of right to privacy or lordship, his right to privacy, he was victim of the crime of the infringement of this right of privacy or lordship. That's what the council was meaning by this lordship.
Awesome.
Maybe the time council lordship, if the council will address issue 4 points. Lordship, issue 4 of the present case relates to the non-consensual collection of biological samples. Your Lordship, the proviso to the section 3 of the Act is stating that provided that any person arrested for any offence committed under any law for the time being in force, except for an offence committed against a woman or a child, for any offence punishment with imprisonment for a period not less than 7 years, may not be authorized to allow taking of his biological samples under the provision of the section hereof. The Lordship is provided with giving a clear description among with the general law and an exception. The general law is that the consent will be required of the accused for collection of any kind of biological samples. However, Your Lordship, the exception is that if in case the victim is a woman or a child or an offence is more than 7 years of imprisonment, then the exception of collecting non-consensual biological samples is allowed. Your Lordship, when we read the except for an offence committed against a woman, Your Lordship, the emphasis over here is on the comment of in the KLE chapter 5 of lordship or any other statute of Indian law or Bharatiya lordship, always the offences against women are raised. Over here, when they are making a singularity as to a woman or a child, that means that any kind of offence. Your Lordship, if for an example, if a rape is committed and the victim is a woman, and if a theft is committed and the victim is a woman, the biological samples will be mandatory according to the exception which has been given under this Act, Your Lordship. Because Your Lordship, considering this is a criminal procedure, Your Lordship, the strict interpretation has to be followed, Your Lordship. Considering the interpretation over here, then if the requirement of biological samples is not there in a theft, then such classification of taking biological samples is not based on any intelligible differential, Your Lordship. Just, Your Lordship, I would have asked them. Moreover, Your Lordship, there is no rational nexus as to the object of the Act and the non-consensual collection of biological samples. Your Lordship, because the object of the Act is the investigation and identification. The police has to investigate regardless of offence is committed against whom. The victim is a woman or a child. It is not matter with the police because the investigation or identification has to be carried out according to the object of the Act, Your Lordship. So now, when such exception is made for only on the victim based, that is a woman or a child, then here itself it is not a rational nexus between the object of the Act, Your Lordship. Therefore, Your Lordship, due to the failure of intelligible differential and rational nexus, the classification made under the proviso to section 3 is unconstitutional. Your Lordship, if I could have 30 seconds for the prayer.
Technically, we try to concentrate on the
No, we know that prayer.
we know that we can put off the prayers from the top.
It's something
Let us know.
Okay, fine.
Okay.
Therefore, in the light of issues raised, arguments advanced, and authorities cited, the petitioner most humbly prays that to admit this petition, to declare the definition of measurements under section 21B by reading of Article 40, to declare the outsourcing of biological samples to a private laboratory without safeguards or states for dedication under the Act and infringes the right to privacy under Article 21, to declare that the provision under section 3 and 6 Regulatory Rule 4, authorizing compulsory collection of biological samples without consent violates protection under Article 20 Constitution, and to issue a writ of mandamus to stop all operations under the Impugned Act and hold the Impugned Act as unconstitutional. And pass any other order or direction that the honorable court may be pleased to grant in the interest of justice to the case. It was an honor to all you. Thank you.
You don't require assistance to research.
must be divided into several subgroups.
Please, please, please. Based on the light and box. If you take a serious note.
Your worship, consistency function for asset intelligence projects. Your worship, I appear on behalf of the respondents. I counsel one and I addressing the first two issues. My member counsel will be addressing the last. Your worship, the whole solution, I would like to proceed with the issues.
Until you have got any, I mean, disputing the facts and as a negative. Contradicting the facts that have been narrated by the other side.
Your worship, if you would like me to restate it.
I don't want to read anything. I mean, since you're the learned counsel for the petitioner, the audience started. Any physical policy or you have to the version of facts as well.
Your worship, we consider the facts and what are the issues that we have in this session. Your worship, the first issue is states whether the absence of a clear definition of what religion is under section 2, clause 1, subclass D of the Criminal History Identification Act 2022, enabling police to use excessive force on other person for extracting biological samples, thereby resulting in arbitrary enforcement, eventually into the violation of Article 40 of the Constitutional Patent. Your worship, I will be addressing this issue in a 4-4 manner. First, your worship, it is with regards to the death of the word measurement certificate and the vagueness of it as so many contributions. Your lordship is in my opinion, your lordship, it is important to know that this act was brought into replace the colonial identification of business act 1920. The act, that act is only restricted to taking fingerprints and strong impressions. It does not go beyond that. The identification of business act 1920 was so it was being found under this act case, which is significant. Your lordship, that is why the word measurements, it is said, we contend that the word measurements is a quantum statistical choice to ensure technological adaptability. The forensic science.
We are going to do that. We are going to do that.
Your lordship, the similar procedure.
No, yes. I so for the page. Also for the it's not very possible for my she's referring to business. I didn't finish on business. I'm just talking about this one. Okay, we have the but it was different.
Yes, correct. It is said that it is present of taking measurements of the context and the other persons for the purpose of identification and investigation in criminal matters and to preserve records in the matters connected therewith and incidental therewith.
So what is the lateral of this track? Right, it's just present in business now.
Your lordship, the business identification act of the consent, it only limited the collection of evidence to fingerprints and palm impressions. Nothing else is taken into consideration, which is why the
This act was taken down.
yes, sir. And the word measurements in the word biological samples was left in it because to ensure technological adaptability. Forensic science is a this constantly evolving, rapidly developing today's day. If the biological samples were clearly stated as the British contended, if they were clearly stated, if the forensic science improves and they use a newer way to collect biological samples, that would again be questioned before the supplement code. So to prevent that, they allowed for the broad term of measurement so that as it is the forensic science
Use the word convince beyond the if it starts from the object of this act, so that it for kind of
if it's done with
when you are investigating the case, he's not present.
it's the
And it does not have any authority to person.
yes,
It's not prepared.
yes,
It's not prepared.
it's correct. But if I may draw your attention, it's a measurement of convicts and other persons for the purpose of identification, which allows the accused to come into this.
Sitting at court,
Who are convicts? They're not able.
Bench is subjective to the word.
which is subjective, expressing you are the recipient, you are representing the Ukraine of India.
So what has the business came
Yes.
to make a legislation whenever an accused has been already found guilty and he is subject to care? What is the rationale that lies behind and making this case use of this?
variables and constraints for the purpose of identification. For the identification in the preamble itself, you see, it says measurements of convicts by the persons for the purpose of identification. The convicts will be the NCRT collects data of the convicts for identification purposes, and the accused are also in the balance of answer, the accused are also taken for identification and investigation purposes. Yes, sir. Your Lordships, and in the case of KLE Law College, it the first flag. It's the first flag.
Yes,
It says that what cannot be delegated is the essential experience, but operational flexibility is permitted. Here, Your Lordship, as long as the policy is clear, it is okay for the state to delegate certain powers that is operational to the executive. Your Lordship, also I would like to draw your attention to section clause 1, clause B, clause 1.
Which authority delegated what powers to the non-governmental entity?
That is issue 2, Your Lordship, that I will address. This is still issue 1, regards to the grant of the type of measurements. Yes, sir. Under section 2, subclause 1, subclause B, it says, therefore, in the last time, after the examination, section 53 and 53A, which is 51 and 52, B and C. Here it says that the magistrate has to be present for the it provides other proper regulation of what the medical practitioner has to do in cases where the measurement is converted. So results is not a present one, but this grant is put so to allow forensic technology adaptability as needs. Your Lordships, my second argument is with regards to statute of forensic as a whole. Your Lordships, the statute cannot be created and explain in here, section 2 defines section 2 clause B defines measurements. Section 3 allows it specifies who being subjected to measurements.
The bench one, it also on the legal statute has two representatives. But the textual interpretation should also coincide with the context as well. But having regard to the context, the factual context here, or the context here, so output is to take to the this is not a deviation from the width of the context.
No, Your Lordships, because if you look at it, when this act is done as a whole, it aligns with the context of interpretation that is specific. It is not.
Yes, Your
The provisions of this is multiplied from the substantive into the provision of section 51 and 52 of the
Your Lordship, it is supplementary to the system.
supplement,
Yes.
not substantive.
in case of conflict between the general law, that being the PNSS, and a special law, that is the 2007. Is there any dependency between the general law and the special law, which should you prevail? Which should prevail?
Because this specific act is supplementary to the PNSS. Yes,
They are connected together,
yes, sir.
not in isolation.
No, Your Lordship. It is by the yes,
Are you confident of this particular submission?
that it must be clear.
No, I mean, saying that the special law should be subservient to the general law.
No, that is not what you're saying. Your Lordship.
No, the bench has posed a question. What is the answer? What is the what is the general principles of constructions or interpretation rather when there is a conflict with the general law?
Special law presents, Your Lordship. Yes.
So then you rightly said, but you right just before that you said that this particular this thing subservient to the
I did not say supplementary, I said supplementary. I did not.
is supplementary to the people subservient.
No, Your Lordship. I will get to that point. Yes, Your Lordship.
Regulate distinctions, you are definitely.
So it's an interpretation of convenience. It's not an interpretation of construction.
Yes.
Please.
Yes, sir. Your Lordship, further for my third point, the second point, yeah. I would like to, I need to,
Direct.
sorry.
Direct the
I would like to request the bench to slightly direct his attention to, in fact,
Second slide.
yes, under, another, question.
Under the
Yes, sir.
which What number is
The flags are
that was so magic release.
yes, yes, Your Lordship.
Magic release.
Your Lordship, there it is clearly stated that the legislature has been laid down what principles and policy of its policy in the next state. And then we got the details to be submitted. So it clearly states that operational flexibility can be provided to the investigating officer. Your Lordship. Coming to my third part of the argument, with regards to the alleged force that was used on Abdul Qadir in the connection of the PLMs. It is allegedly in the nature and the High Court admitted on the basis of the because it will establish the non-broken chain of custody. The alleged force that is used is taken via the bruising on the face and the cut of the face. Even if we assume that the police used physical coercion to take the biological sample evaluation. Unlike the case of Manikarani versus State of India, it was stated that a statute may be constitutionally valid, while the action taken under it may be unconstitutionally evaluation. Here, if there is physical coercion that is implemented, it would really lead to custodial misconduct. If you look at the section 2 clause 1 subclause B, these are mostly referred in section 50 of steps, which is 51 to 54. Here it requires the presence of a medical practitioner when the DNA samples are supposed to be taken, which in the fashion related using has not been mentioned because there is no mention of medical transmissions. Here, even though safeguards are present, even though proper laws are stated by the state, the officer has gone beyond his power to collect evidence. This is a case of misconduct precaution and not this cannot be used as a beyond.
He is your officer. He is your officer.
Here, assuming that he is in case the laws and the rules for the police and the way in which the data samples are being taken are already stated in the respective statutes. Even with this, they have gone beyond the waiver. Because if you look at the facts, they have not mentioned that.
Clause 3 of section 4 of the Act 22 Act. They were not given any SOP how to collect, how to delegate the powers. Such amounts to be accessibility.
Yes, Your Lordship.
Because you have not taken any action against the private party because there is no any penal person.
Also, in terms of section 9 of the Act, order has to be made. The order could also be the form of an SOP. In the absence of any rules or any difficulty, the order could be made. That just bypassing section 9, also section 8, which is the energy order to make rules.
Collecting the samples, while collecting the samples, you have not assigned any results while you are collecting the samples.
And this is not also access to delegation. So that particular validity has to be struck out. The constitutional validity has to be struck out.
Yes, Your Lordship. In the section of 5152, it says that the collection of investigative DNA is to be collected during the investigation without the designation of the medical practitioner present. Which was not present in this case. If the medical practitioner was present, then it would be because the necessity of DNA.
That was not the first question. Because you have just made use of subsection 3 of section 4 in the absence of, bypassing section 8 and section 9. So, bypassing section 8 and section. So that's what was my brother's question. So, in the absence of any SOP or this thing, how could the DNA sample be made? It is what private agency.
Yeah, actually, private agencies, the derivation of other private agencies, that is to prove your Lordship.
Oh, sorry.
Your Lordship, the last one of my argument is with regards to there is anti-affiliation and argument next time. Stand by the proportionality investigation. In the case of Taliban versus India, it was stated that argument against rights only that legislation is continuous, irrational, or independent. But also, when this is read all together, there is a clear objective defined categories and proper there is a control that is present. And further, Your Lordship, in the case of moderating violation design central versus there is a fourth wrong as well as data. One, whether the act is the aim of the act is implement. Two, whether there is a national election in the act will be objective. Three, whether there is necessity. And four, there is proportionality. Your lordship, the aim is implement because it is with regards to effective criminal investigation. And the national election is a biological identification, improves accuracy, and aids the investigation. And the necessity is satisfied because modern investigation requires scientific methods, and with the progression of the modern scientific methods, it is to be adapted. And fourth, in proportionality, it is met because the act is concerned with the physical identifiers and not just testimony, and not testimony to that. I think we move on to issue two to case with us. The issue two is with regards to delegation of the power that is given to the prime ministry and whether it violates up to 21 years. This is again the relevant for method. Lordship, the first point is with regards to what sort of function you are delegating. Your Lordship, again, as stated in the Delhi Laws Act, it was stated that only essential legislative functions cannot be delegated, but operational assistance can be delegated. Your Lordship, I would like to kindly direct your attention to the fraction basis. Under para 7, the last 3 lines, it states that principal was tasked with storing samples, operating servers and providing analytical assistance to the same entities, which clearly states that all the only power that they have was regarding technical support and analytical support. The actual function with regards to more be subject to correction and more important.
That is not the question here, man. The problem of interactive is when you collected the samples. And after that, you published, you released that all these personal things to the public. Then causes that was missed by the agency. When you have given a delegation of powers to the agency, private
It is to see that whenever we employ a private in the agency of such nature, that is what has been done here. There is a possibility of these collection of the data, data is likely to be and likely to throw danger-free victims so that what has been done in the present case must be perpetrating the events. That is what the extent of the case is. That is why the challenge.
Also, it is that has led to a loss of life.
Yes.
that is the reason these the powers is delegated to the government agencies. They will be as services, they will be as swatting certificate, they will be as what as looking. If we make mistakes, they will be removed from the service or will be convert. One could be found out. But here, there is nothing so. The government agency made a big mistakes and they will be particular statement for a person.
Your Lordship, the agency did not indicate there was a foreign cyber attack that happened, which Your Lordship, the
These are the my brother was still because anxious consideration there has been a government agency which English was supposed to be very tight. Since it was a private agency, there was breach in the cyber. That's it.
I again like directed attention to the factual witness, where it was stated that the chief sector in the again with the para 7, line number 4, it says physical private company that was trusted by into businesses for data collection. The Lordship, this was entered into to include self-company to include the way in which the technical storage has been done. Again, sorry?
After committing the suicide, you are dead.
No, Your Lordship, parallelly addressed in, I guess, can be that. Your Lordship, again, in the last 3 lines of
No, that is not the other issue, madam. When you delegated the powers, that used to be taken of 1% life. That's the reason. There is a reason that is an excessive to delegation.
I would like to submit the PPT to the personal data protection side. Yes, Your Lordship.
Which section? Which section?
It's under section
4 plus 3. 4 plus 3.
the two subsection idea.
Okay.
Two subsection idea. It defines data usually, and through the subsection will be the subclause comes of data processing function. Here the NCRB gets the private agency gets power not through the method of understanding, but because the NCRB's power from the DPDB Act to delegate certain, it's just operational system that is provided by the Genesica. Wherein again in the country, the last line of the parasection, it states that Genesica is responsible for creating a separate database where it was stored and access to this database was monitored and distributed to the officials authorized by the government.
Is that your contention stating that the data principle should not be in library, rather the data from history should be in
No, Your Lordship, if we are
Another point is, madam, when assigning a delegated policy in some agency, for example, if a person approach institution is approached to open the school, then the education department will see the infrastructure, teachers, and all of these. But after considering all of these, then the department will give a license to run the school. You will state, have you taken all the consideration of protecting protecting this private platform? And protecting all the measures after collecting the shamas.
Your Lordship, the chief secretary of the private entity is already scientific trust by a religion.
That is not the state.
Your Lordship, I think it's already scientifically, I mean, it's already trusted by for storing and speaking test the data for a secure manner. Your Lordship, even further, the authorization to access the data is given to personnel that were provided the power from the NCRT and from the state. And the private entity given our access to the data, it will just technical support and litigation.
And how it possible?
Your Lordship, the foreign cyber.
It was just a good procedure.
Yes, Your Lordship. Your Lordship, with regards to the
Someone may say,
yes, Your Lordship. The third and final part of my third and then the final part of my argument, Your Lordship, is with regards to whether the safeguard certificate. Your Lordship, there was an NDA signed, there was the memorandum of understanding signed, and the ATTB Act also protects the source of power for the example anyway. Your Lordship, the Constitution doesn't mandate the state to personally operate any sector. It can allow operational services from the private usage. Further, Your Lordships, the last part of my argument is in regards to the fact that the applicant of cyber act will have happened to any technical system. It is not limited to one or two, that is even if the state, it was arranged to state individuals, as you mentioned, that technical service may under threat of being a false alert. I mean, that cannot be predicted. Only certain precautions can be taken to protect the data privacy, which is why we say that participant input is not violated. But and Article 14 is also not violated for the chief. My concern is arrest.
we lost the judge.
So actually, with the permission of the honorable bench, I would like to continue my submissions for issue 3. Issue 3 is a concern with whether the collection of biological samples from the accused violates Article 20, Clause 3, and Article 21 of Lodges. The respondents respectfully submit, but it does not get Lodges, and I get to violate this in a fourfold manner of Lodges. And it is going to be that sequentially. The first one being biological samples of physical evidence and do not attack Article 20, Clause 3 lodges. And outside a lordship, Article 20, Clause 3 protects the accused from being compelled to be a witness against himself in lodges. That is what the petitioners have stated and reinstated in the lodges. But
Because is that not bypassing the legislative matter of Article 20?
your lordship, I reject to
Article 20 subclause.
yes, your lordship, I reject to precedent which waive down the clear distinction between physical identifiers that are being taken in this particular case, and then the as per what the petitioners have referred to Selvi versus State of Karnataka, which clearly differentiates the testimonies which are compared by biologists. I would like to begin by stating state of Bombay versus KLE Law College, which where the honorable
What is confirmation?
Fact having logics. Anyone else? To be a witness means to furnish testimonial evidence relationships, physical characteristics such as fingerprints, handwriting, or bodily samples do not amount to testimonial compulsion relationships. And emphasize. Yes, sir. Your lordships do not other principles that are implied, but I combine it in our particular case, your lordships.
No, but the principle is not there. This is the part of the competition.
Yes, you have to respond.
The one which is identified in
One thing, your lordships, I think there has been a mistake. I will get this flag list.
confusion caused by inclusion of break of values and
No, your lordships, it's a different piece on its own. A slide like this will make the lordships.
you different and
Yes, sir. I will. Your lordships, I'm so sorry to direct your vote, but the flag has not been has not been stacked properly. But if you pick the 3 pages right, your lordships, shall I read out the
yeah.
your lordships? So your lordships, for the judgment directly states that your witness is not equivalent to furnishing evidence, your lordships, and I will explain it in this particular. Yes, sir. Your lordship, this is state of Bombay versus country by the Algobad, your lordship.
Is it the 2 pages or is it the 2 pages or the 3 pages?
I see. Yes. It is it's three mentions. The lordships are. I would like to again emphasize the physical characteristics of lordships. DNA extraction does not require communication of mental content, verbal or written testimonial lordship. It merely collects physical identifiers like it has been done in this particular case, your lordships. Therefore, the binding proceeding, according to the binding proceeding, biological samples falls outside Article 20 plus 3 your lordships. Your lordships, moving on to the second point of my argument, your lordships, protection against self-incrimination extends only to the compelled communicated testimony, your lordships. To rely on what I stated before, your lordships, the respondents further submit that, in contrast with what the petitioners have said, Central State of Karnataka prohibits narco-analysis and grave mapping, your lordships. And here, there is a clear distinction that has been made from Central State of Karnataka along with this particular yoga, which basically states that there is a distinction between physical identifiers like fingerprints, blood samples, and that are constitutionally permissible, unlike what has been stated. Central State of Karnataka.
Principle is universal principle. Principle is a universal principle. So, how do you say that the Century's judgment rendered Century's is not applicable to this particular case? Ultimately, so it's a criminal jurisprudence that we are talking about. Or if we are undertaking the laws to consider the
What is everyone is trying to say is that
ultimately whether the conviction results in conviction due to the laconious right of the legislative framework is what we are deciding on. So technically, in our opinion, there is a laconious legislative framework which has resulted with an acquittal and a further thing of a lawsuit.
your lordships, we are the respondents are not denying that the disease, we sympathize with the disease matter of fact, but we are not. But the question here is the petitioners are questioning the entire statute on its own, your lordships. But the entire statute is not wrong, your lordships, and I will get to why it is not wrong, your lordships.
When you consider the fact that certain portions of the statute is
Your lordships, I would like to bring upon a precedent matter of fact. Accuracy was the state of Punjab. While this case upholds statutory authority, it was stated that the case in where misuse of power by police in execution does not mean the entire statute itself is invalid, your lordships. And going by that, your lordships, I would like to build upon my arguments for your lordships. Your lordships, I'll be moving on to the third point of my argument for issue 3, your lordships. That is, consent is not an essential component in the due process in doctrine driven identification, your lordships. The petitioners argue that the lack of consent invalidates the procedure. The respondents humbly submit that the constitutional prerequisites in all investigative measures do not state so. Under the case of some Union of India, privacy is subject to law promotion restriction hierarchy. And based upon this, I will be applying in our particular case. Here, the aim is legitimate lordship. The inclusion is regulated by law and lordships. And therefore, the absence of consent does not render the clause as unconstitutional lordships. Moving on to the fourth point of my argument in lordships, even as an argument through the manner of extraction involved excess force, that it does not invalidate the statute itself, as I stated before, your lordship, in fact, this is the state of Punjab. The admissibility, data evidence, and credibility will not strike down the legislative power. Authorities is the collection of your lordships. Further, the criminal application evaluates evidence on reliability of your lordships, not merely on the mode of collection. Thus, the statute remains constitutionally valid. An alleged coercion is a factual issue of the trial, and it does not violate Article 20 clause 3 your lordships. Moving on to issue 4 your lordships, much obliged. Issue 4 is concerned with the classification under the Act, particularly the enhanced investigative framework, in cases involving grave offences such as sexual offence against children violating Article 3. The respondents respectfully submit that it does not have options, and my arguments are again going to be in a four-fold manner, which will be addressed sequentially. Much of that objects. The classification is based on intelligible differentials. Article 14 permits classification so long as based on intelligible differential. The classic state, the classic test which was laid out in detail.
How did this include differential according to the fund?
Your lordships, I will be getting to the implications in our particular case, but the mere the meaning of intelligible differential would be
There's a few events to survive. But how was this? There is an intelligible differentiation.
I agree.
In the present case.
Yeah, here the lordship is based on the gravity of offense, vulnerability of victims, evidently complexity of crimes such as sexual assault in lordship, and that is what brings in the intelligible differential.
We don't have a objection. That this is the inner offense. We don't have an objection. Thing is that when a person is refused to give his sample and without mistake made any specific rules, regulations, SOPs, how to collect the samples,
Safeguard it.
The state has provided the state has provided statutes and procedures as laid out in the Act for lordships. My contention is that
so without making the rules, we think that the decision already made, which is constitutional,
here, the mere designation, I would give them assistance in an investigation of such heinous matters, which your lordships would agree, being the fact that it is a POCSO case. Given that your lordships, I will be explaining on why it is important and how so your lordships. My further arguments.
Much of it. Clarify the question in your question.
Sexual offences against children are not ordinary crimes, your lordships. They are crimes that are having heightened societal harm, and they often occur in private spaces without high vision, where in this particular case, it is a minor, your lordships. The Act distinguishes between the routine offences and grave offences involving vulnerability to your lordships. This is clear, this case is clear, and this is clear. Moving on to the lack of access aspect of the most important. The legislative objective is effective investigation of offences where the direct evidence is scarce enough. The testimonial evidence may be unreliable due to age or trauma as specified by lordships. This directly exists permitting biological sampling and achieving accurate identification in such offences is where the statute really is to the point of. In state of West Bengal, Anwar Ali Sarkar, laws were struck down when there was no national nexus to the lordships, but in contrast, here there is a particular national nexus.
Also, but the remaining of on that particular event, but maybe the other side.
Yeah, such a bit of contrast.
You have to demonstrate where the laws, the constitutional value is upheld. Where the constitutional value is upheld, you should rely on that particular precedent. Merely relying upon the precedent where the laws are struck down.
In the lordships,
You are taking the, is that not right? So how does the student, I mean, it's relevant in this particular case?
Your Honor, the principle laid down shows that the law is not so illogical. Further, your Lordship, here the classification from rape, not arbitrary as me and my co-counsel are trying to research.
Demonstrate that this game upon the process of the constitution has been adopted. So how is that particular president, this ABK and this president?
Your Lordship, it was just a million and the contrast Lordship. If I may, I would try to explain the answer to this. The third point of my particular argument enhances investigative powers and sections against children reflect legitimate victim-centric jurisprudence and options. Modern constitutional jurisprudence recognizes the need for victim-sensitive approach to options. In Prathamati Devakar versus State of Tamil Nadu, this honorable court emphasized that the criminal procedure must adapt to meaningful justice, particularly in cases where there are vulnerable issues, as such in this particular case, Your Lordships. The state has a heightened duty to protect children, Your Lordships. Enhanced investigation rules such cases are not punitive towards the accused, Your Lordships. They are protective towards the victim and the society, Your Lordships. Article 14 does not prevent the state from responding differently to the rights of the real society to harm them. Rather, failure to do so would undermine the constitutional obligation of justice. Moving on further, Your Lordship, the fourth point of my argument, Your Lordships, Article 14 does not mandate uniform investigative procedures, Your Lordship. It does not need identical.
Uniform investigative procedure, right? So the 90% equality for not equal protection in some law. So how let us what to do with uniform investigative procedure?
Your Lordship, it is nobody identified in all the circumstances, Your Lordships. That is, as mentioned in Neta Gandhi's or my co-counsel had stated, it is where the court clarified that fairness is contextual, Your Lordship. Procedural identification based on offences, gravity, in constitution, is constitutionally permissible, Your Lordship. And moving on, Your Lordship, plus uniformity is not constitution, is not the constitution from unreasonableness is your option. In accordance with Neta Gandhi's Your Lordship. As long as the classifications satisfy the visible differential and rationalities, Your Lordships, Article 14 is not hereby violated, Your Lordships. Your Lordships, you may comment if there are no further questions, I will move on to the prayer, Your Lordships.
Some questions are there. You referred to 15th century jurisprudence.
Yes, Your Lordships.
Here, my brother was asking that question to the other side. Who is the looking to the proceedings?
Your Lordships. It can be seen as two aspects, Your Lordships. This is on what I would like to say is that the two victim one is the child, Your Lordships. That's is the victim according to factual victim. I didn't mean that.
Yes, yes, you can.
According to factual victims, the victim is child, Your Lordships. But in this particular case, the petitioners are arguing for it as in the deceased being the victim, Your Lordships.
The report has declared, the report has passed an award, passed it, acquitted.
Yes, yes, sir.
Acquitted that accused is not getting murder due to failure of investigation.
Indeed, Your Lordships. But what?
Yes, he has lost his life by committing suicide. When the sub agency has published his photos indicating that the person who is in the custody.
Your Lordships, it was this one, the part of that.
Then who is the victim? And you are defending yourself that this the relationship is in the victim the secondary rights.
Your Lordships, to make it more simpler, what I would like to say is that the state's argument is really based upon the fact that the statute itself is not unconstitutional to what the petitioners are supposed to do.
When it is constitutional, if you are supporting some SOPs and not, then that in that circumstance it is a constitutional. Without there being anything else, and forcefully collected the samples and cutting his nails, all the things were into suicide.
Now, Your Lordships,
You just read about statute what a victim is. And coming to that, who are victims here? Who's the victim?
Your Lordship, that is stated to be as seen as two aspects, where according to the factual matrix, the victim here is the minor, but what the state actions are posing is the
Who's the victim? As per the statute or as per that who's the victim?
the deceased person.
As per the statute.
The Lordship, I counsel to advert the Lordship can much of life. In light of the facts stated, circumstances of the case, and the arguments advanced hearing, I most respectfully claim that this honorable court may patiently please to dismiss the petition as being devoid of merit and uphold the constitutional validity of the improved provisions, Criminal Procedure Identification Act of 2022, hold and pretend the compulsory collection of biological samples does not amount to testimonial compulsion and does not violate Article 20 Clause 3 of the Constitution. Hold and declare the out of storage and ancillary assistance of biological data private entity under statutory and contractual safeguards and the government provision does not constitute excessive regulation, nor does it infringe the right to privacy under Article 21 and or render any order direction relief that may deem fit in the best interest of justice, fairness, equality, and good conscience. For this act of kindness, the respondent shall duly bound forever to create it.
Yes.
Maybe one of you is going to address it in one. Your Lordship, before moving on to the council is your Lordship's council and clarify any concerns that it is restricted is only restricted to the inverters. If only one, nothing different. Well, very long we have been advised by the organization not to always be further submission in the stage of several forms.
The first is that the respondent has relied on the only but the question under Article 14 also arises, and also under 20 how does the second will use either use? Because what we see is whenever state agencies want to employ any private contractors or want to avail any services from private entities, they have to call for a tender and they have to, in this case, where we saw two founders of officials in science. Even our for instance,
Yeah, so the respect of the government management of the state places in all the more questions to be decided by this court at this point in time. But we just rely on what actually has led to the excessive power that by the agency, and that has likely to come before this commission and before this court. I think that what I like to annihilate this.
it's like in Bharat Federal of the fact sheet also states that the private entity is tasked with storing the samples as well. But under the Act, the NCRB shall store and retain under four categories of obligations. So the NCRB is very conveniently substituted their obligations to the private entities. So this is also amounting to accessibility. And further, the Lordship also says that analytical assistance must be given to the state agencies. So here, even for analysis, even for criminal trials, the first way that whenever any forensic is collected or measurements is collected, it states the FSL labs will do the analysis, and also under section 45, when such an FSL is introduced before the honorable court, it is the forensic science officer who analyzes such the specimen who will be testifying before the court. But by extending this provision of giving analytical assistance to the private entities, it is also creating the risk of the reliability of the evidence.
Zero one.
Zero one.
09.
Subject, okay.
Sir,
So it's very no additional from it's no
Yes, sir. My relative from the opposite, the commissioner stated that the state cannot do and use the number of tender fee. The other thing is the discretion of the state went into one time. So we had argument For the state to administer contact, because in lots of identify evidence and this question by the petitioners, the lots of the personal authorized to analyze was the people that the NCRB authorized to do so. Only the authorized person that the NCRB only had access for the analytics for the access to the data. Look at the package data discussion under the class 7 states that the private entity had to create a second database to store, which is what storage into the actually assistance project. Again, the hours to enter and access the data given to the PWD study, which they came about.
Use the report inside of it. Oh, hello, sorry. Please.
Thank you, teams, who that open proceeding with the semi-finals round of London. I now request the faculty in charge, Ms. Shubha Kapari, Assistant Professor of Law, who is taking the judges report.
Good afternoon. We have with us Honorable Mr. Vidyadhar Srimurthy, presently serving as Additional City Civil and Sessions Judge, Commercial Court, Bangalore. A graduate in BLLB Honors and LLM from Karnataka University, Harvard. He has enrolled as an advocate in 2005 and practiced across Belgavi, Tripoli, and Raga, gaining substantial experience in civil and criminal litigation. Before his elevation to the district judiciary in 2018 as a Derek district judge, he has since served in multiple judicial capacities, including Principal Presiding Officer of the Family Court at Belgavi and Additional District and Sessions Judge, bringing extensive trials in commercial and litigatory experience to the bench. His combined experience at the bar and the judicial service reflects strong doctrinal grounding and courtroom acumen well suited to academics and advocacy evaluation. Mr. Darshan Suresh, who is the founding partner of Trust Law's dispute resolution practice in Bengaluru, with over 14 years of professional experience spanning civil and criminal litigation, corporate disputes, insolvency, real estate, intellectual property, regulatory compliance, and transactional matters. He began his legal career after graduating from Bangalore University and enrolling with the Karnataka State Bar Council in 2010, subsequently gaining valuable training at leading firms and as seasoned advocates before co-founding Trust Law in 2016 and leading its dispute resolution team. Mr. Suresh regularly appears before multiple high courts across India and Supreme Court of India, representing a broad range of clients, including individuals, corporations, government entities, and statutory bodies, and is credited with several reported judgments and legal publications demonstrating both doctrinal depth and practical courtroom experience. Mr. Mahandev Singhi is an experienced advocate and presently serves as president of the District Consumer Disputes Redressal Commission in Madhyadevi. With over 2 decades of professional experience, his practice has been primarily focused on criminal and constitutional litigation, appearing before the High Court of Karnataka, Harvard bench, and various trial courts. He has served as special public prosecutor in fast-track courts and as special public prosecutor for the Lokayukta, Belgaum district, handling significant prosecutions and complex statutory matters. In addition to his prosecutorial and courtroom engagements, he has contributed to legal education as a guest faculty member and has actively participated in legal literacy initiatives and moot court education. His extensive experience at the bar and his combat legal operation reflects strong command over trial advocacy, evidentiary assessment, and statutory interpretation, equipping him with seasoned adjudicatory insight for evaluating competitive advocacy. On behalf of KLE Law College, I thank you, sirs, for giving us please return to KLE Law College to present our report without meeting.
Thank you, judges. Thank you. Now request the team ushers to escort the team outside.